Dear students, today we take up for discussion Criticism of Hart's Positivism by Dwarkin, Fuller and Devlin. In the concept of law, Hart sets out his view of the foundations of a legal system. That view and the methodology underlying it are those of a legal positivist. Hart is unquestionably a positivist, particularly in the sense of maintaining, for analytical purposes, the separation of law and morality. He acknowledged the core of indisputable truth in the doctrines of natural law. He concedes that there is a minimum content of natural law shared by both law and morality. He says, law, coercion and morality are different but related social phenomena. According to him, law is a union of primary and secondary rules. Primary rules are duty imposing rules, secondary rules are power conferring rules. Primary rules and secondary rules of recognition, change and adjudication coalesce into the law, which is the very essence of a legal system. The rule of recognition exists in every legal system is the central theme of Hart's concept of law. Hart's concept of law has come for sharp criticism from Ronald Dwarkin and Lon L. Fuller, who have raised doubts about his concept of law as a combination of primary and secondary rules, and his exclusion of morals from law and his model of positivism. These two juries have raised serious doubts about the very nature of legal positivism of Hart. Dwarkin's criticism. Professor Ronald Dwarkin has criticized Hart's version of law as a set of rules that are to be identified by means of the rule of recognition. He questions, is law merely a system of rules on which Hart has based his model of positivism? Dwarkin says, a legal system cannot be conceived merely as a code of rules. He says there are principles in a legal system besides rules. Dwarkin makes a distinction between rules and principles. He says, legal system has to be conceived as an institution based on certain standards, principles and policies. The question arises as to what is the difference between rules and principles. According to Richard Turr, there is a logical difference between rules and principles. Principle is the reason for a rule. Rules are thought as detailed, whereas principles are general. As Patton pointed out, there is a vast gulf between the elasticity of a general principle such as public policy and rigidity of a detailed rule. A principle is the broad reason which lies at the base of a rule of law. Rules are more specific and detailed than principles. Walker says, principles are the broad formulations of reason or generalizations which underlie and comprehend particular rules. They are broader than rules, and that rules are categorical precepts attaching a definite, distinct and detailed legal effect. They are more specific and detailed than principles. Harari observes, by looking for principles in the law, one is looking for the very essence of the law, its raison d'etre. Dwarkin has elaborated the logical difference between principle and rule. He says, a principle is a standard that is to be observed because it is a requirement of justice or fairness or some other dimension of morality. For example, no one shall be permitted to profit from his own fraud or to take advantage of his own wrong is a principle. This is substantially different from a rule. For example, the maximum speed on the turnpike is 55 miles an hour. Rules are applicable in all or nothing fashion. Rather, a principle states a reason that argues in one direction, but does not necessitate a particular direction. Principles have a dimension that rules do not. That is the dimension of weight and importance. The principle that law does not permit people to profit from their own wrong did have sufficient weight and was cited in the case of Riggs versus Palmer. In Riggs versus Palmer, the defendant's right to inherit under the will of the man he murdered was challenged. The brief facts of the case are that Francis B. Palmer made his last will and testament, in which he gave small legacies to his two daughters, Mrs. Riggs and Mrs. Preston, the plaintiffs in this case, and the remainder of his estate to his grandson, the defendant in this case, Elmer E. Palmer. The testator at the time of his will owned a farm and considerable personal property. At the date of the will and subsequently till the death of testator, Elmer lived with him as a member of his family. Elmer knew of the provisions made in his favor in the will. To prevent his grandfather from revoking such provisions and to obtain the speedy enjoyment and immediate possession of his property, Elmer willfully murdered his grandfather by poisoning him. Then he claimed the property under the will, as the will must have effect on the death of testator according to the letter of the law. The question arose whether Elmer E. Palmer, who murdered his grandfather by poison to obtain and enjoy the possession of property left to him by his grandfather's will and testament, be allowed to obtain and possess the same. The court held that by reason of the crime of murder committed upon grandfather, Elmer was deprived of any interest left by the testator. The court pointed out that all laws as well as all contracts may be controlled in their operation and effect by general fundamental maxims of the common law. No one shall be permitted to profit by his own fraud, or to take advantage of his own wrong, or to find any claim upon his own iniquity, or to acquire property by his own crime. These maxims are dictated by public policy, have their foundation in universal law, administered in all civilized countries, and have nowhere been superseded by statutes. The court referred the principle cited above as one of the general fundamental maxims of common law, controlled the operation of legal rule, and consequently held that Palmer was not entitled to the inheritance. According to Dwarkin, the difference between legal principles and legal rules is a logical distinction. Both sets of standards point to particular decisions about legal obligation in particular circumstances, but they differ in the character of the direction they give. Rules are applicable in an all or nothing fashion. Principles are a matter of more or less, whereas rules are a matter of yes or no. Another interesting illustrative case cited by Dwarkin was Henningsen versus Bloomfield Motors Incorporated. In this case, Mr. Henningsen purchased a reconditioned car from an automobile company. The car was intended as a Mother's Day gift to his wife. The purchase was executed solely by Mr. Henningsen. The contract for sale was a one-page form and contained paragraphs in different sizes on the front and the back of the form. Mr. Henningsen testified that he did not read all paragraphs of the contract. The back of the contract contained a clause limiting the liability of the manufacturer. It reads, "The manufacturer warrants each new motor vehicle to be free from defects. its obligation under this warranty being limited to making good if any defect is found at its factory, any part or parts thereof. This warranty being expressly in lieu of all other warranties expressed or implied. The car was delivered and there were no problems for 10 days. On the next day, when Mrs. Henningsen was driving the car at 20 to 22 miles per hour on a smooth 2-lane highway, she heard a loud noise. The steering wheel spun in her hands and the car suddenly veered and collided with a wall. The car was damaged severely and declared totaled by the Henningsen's insurance carrier. The defendants refused to repair the car under warranty since they claimed the express warranty was limited only to repairing the defective parts and that it was not liable for damages caused by defective parts. The plaintiffs filed a case for breach of implied warranty of merchantability. It was held that automobile purchasers may recover damages caused by defective parts under an implied warranty of merchantability, since automobile manufacturers and dealers may not limit this warranty to replacement of only defective parts, as this violates fair dealing and public policy. The court pointed out that the court will not permit itself to be an instrument of injustice. In the light of these illustrative cases, Dwarkin argues that law includes not only rules but also principles, standards and policies. Hart failed to acknowledge the importance of principles in his analysis of legal system. Hart holds that the judges have the discretion to create new legal rules through extra legal standards when the existing law is not ascertainable and provides no guidance to the judge to apply the law to certain situation. Hart is of the view that judges make a new rule by using their discretion. This view was rejected by Dwarkin. He says judges do not have a discretion in the strong sense. Rather, a judge has a duty to appeal to certain principles and not to others. Hence, judicial discretion is a discretion in one of the weak senses. For every problem, there can be only one right answer. That right answer is expected from judge in his verdict. Therefore, judges have discretion in the weak sense of the term. According to Dwarkin, the principles are genuine, moral, or political, and that judges are duty bound to take into account those principles in their decisions. Even in the absence of rules, judges are bound by the principles, standards, and policies. Though unwritten, these principles are part of law. This aspect has been ignored by Hart in his The Concept of Law. Hart-Fuller controversy. Hart's concept of law was attacked by Fuller in his The Morality of Law. Basically, Hart was a positivist, but Fuller was a natural law philosopher. This resulted in some sort of debate, discussions, or controversy relating to certain issues of the legal system because of their contradictory approaches towards the nature of law. Fuller's view towards Hart's positivism is discussed under three heads: internal morality of law, doctrine of core and penumbra, and retroactive criminal statute. Internal morality of law. Professor Lon L. Fuller regards law as a purposive system, and the purpose of legal system being to subject human conduct to the governance of rules. In his view, ease and ought are inseparable, and it is inconceivable to assume the law without morality. If law is indifferent to morality, it is enforceable for the time being because of public power behind it for its enforcement. However, it is bound to fail in the course of time. Therefore, law for its endurance must have connection with morality. At least in the intestines of law, there should be morality. Hart is of the view that there are no logical connections between law and morals. Professor Fuller argues against the separation of law and morals. He says, morality is implicit in law and it is impossible to study and analyze law apart from its ethical or moral content. Fuller opines, legal positivists have committed the mistake of assuming that a rigid separation of the is and ought, that is, separation of positive law and morality, is possible and desirable. Fuller rejects Hart's distinction between order and good order, the former meaning divide of morality and later implying morality. Fuller says, law considered merely as an order contains then its own implicit morality. This morality of order must be respected if we are to create anything that can be called law, even bad law. Law by itself is powerless to bring this morality into existence. He is of the view that the authority to make law must be supported by moral attitudes that accord to it the competency it claims, what Fuller describes as external morality. But this is not enough, without the internal morality of law itself. Fuller says Hart has completely ignored what he calls the internal morality of law. According to Fuller, external moralities and internal moralities of law reciprocally influence one another. A deterioration of the one will almost invariably produce a deterioration in other. In short, every law has its internal morality, and positivistic efforts to separate them are not just difficult, but one fundamentally misconceived. According to Fuller, law has external and internal morality. External morality is morality of aspiration, internal morality comprising of irreducible minimum requirements with which a law has to comply. He lays down 8 requirements of inner morality of law, which legal system must comply if it is to succeed as law. They are: there must be rules. The rules must be published. Rules must be given prospective operation. Rules must be understandable. Rules must not be contradictory. Rules must not require conduct that is impossible. The rules must not be changed frequently. There must be congruence between the rules declared and their actual application. These 8 conditions constituting inner morality of law are procedural version of natural law. If any law or legal order fails to satisfy either of these requirements, it is not worth to be called as law, so said Fuller. Hart's doctrine of core and penumbra, Fuller's comment. Fuller has shown some anomalies in Hart's doctrine of core and penumbra, which is concerned with the role of judges in a given fact situation. The fact situation may be covered by definite, certain, or authoritative law, or there may be uncertainty, where judges are called upon to interpret the law to achieve the desired social purposes. In plain cases, there is little need of interpretation, and application of law is automatic, but problem arises where the case is problematic and uncertain. Thus, Hart does not favor liberal interpretation of a statute and is of the view that the judges should strictly adhere to the literal, formal, or logical construction of the law and desist from judicial creativity. Fuller demonstrates some of the anomalies in Hart's doctrine of core and penumbra by illustrating the following examples. Supposing by a rule the parking of vehicles is prohibited in public park. What is meant by vehicle? Obviously, vehicle means a motor car, a truck, or a bus, and the rule is applicable to such situations. But there may be cases where it is not clear whether the rule applies to bicycles or tricycles or mechanically propelled toy plane. Hart would not spare a child cycle, tricycle or toy plane, while it should not be covered by the said rule. Fuller says the functional purpose of such a rule is that parking of vehicle may lead to accidents, and to avoid such accidents, the rule should be interpreted in the light of social aims. Fuller demonstrates another instance of the untenability of Hart's doctrine of core and penumbra. Suppose there is an enactment. It shall be a misdemeanor punishable by a fine of $5 to sleep in any railway station. The purpose of this rule is to give comfort to weary passengers so that they may not keep standing on their feet and occupy benches of the station while they are in transit. Thus, sleep is the standard or settled instance. Two persons are brought by the prosecuting police before the judge for violating the statute. The first is a passenger who was waiting at 3 a.m. for delayed train. He was sitting on the bench, but dozing and snoring. The second is a man who brought a blanket and a pillow to the station and was intending to sleep on the bench to pass the whole night. He was arrested before he could sleep on the benches. The question arises, which of the two cases present the standard instance of the word sleep? Hart would convict both, while Fuller the only one who wants to pass the whole night. It is the duty of the judge, says Fuller, to interpret the word sleep used in the statute to spread oneself out on the bench or floor to spend the night, or as if to spend the night. He says it is not possible to interpret the statute without knowing its aims and purposes, what evil it purports to avert and what good it is intended to promote. We must, in other words, be sufficiently capable of putting ourselves in the position of those who drafted the rule to know what they ought to be. It is in this art that we must decide what the rule is. Retroactive criminal statute and the grudge informer case. Another aspect of Hart-Fuller controversy is about the use of retroactive criminal statutes to invalidate certain illegal and essentially immoral actions of the Nazi regime in Germany. In the post-World War II period, the German courts were faced with difficult problems. It was neither possible for them to declare the whole dictatorship illegal, nor to treat every decision or enactment emanating from Hitler as void. On the other hand, it was equally impossible to carry forward into the new government the effects of every Nazi perversity that had been committed in the name of the law. In Nazi Germany, some persons were convicted with imprisonment or death sentence for their actions against the regime at the instance of informers. When the new Federal Republic was established after the World War II, the informers were prosecuted for such crimes as murder, false imprisonment, or unlawful deprivation of another's liberty. The informers' defense was that their actions were completely legal. The case of the grudge informer. The Hart-Fuller debate was in relation to a decision of a post-war West German court in the following case. In 1944, a woman wishing to get rid of her husband so that she can move in with her lover reported to the authorities the derogatory or insulting remarks he had made against Hitler while home on leave from the German army. The wife was under no legal duty to report his acts, though what he had said was apparently in violation of the statutes, making it illegal to make statements inimical to the welfare of the Third Reich or to impair by any means the military defense of the German people. The husband was arrested and sentenced to death by a military tribunal. However, after serving some time in prison, he was sent to the front, and the death sentence was not executed against him. Following the defeat of the Nazi regime, the wife as well as the judge who had sentenced her husband was indicted under the German Criminal Code of 1871 for the unlawful deprivation of another's liberty. The wife pleaded that her husband's imprisonment was pursuant to the Nazi statutes and hence she had committed no crime. On appeal, the German Court of Last Resort in criminal cases held that the sentencing judge should be acquitted, but that the wife was guilty of procuring the deprivation of her husband's liberty by denouncing him to the German courts, even though he had been sentenced by the court for having violated a statute, since, to quote the words of the court, the statute was contrary to the sound conscience and sense of all decent human beings. The court rejected wife's reliance on Nazi law. The reasoning of the Court of Appeals against grudge informers, such as the wife in this case, has been hailed by Lon Fuller in his writings as a triumph of doctrines of natural law and as signaling the overthrow of legal positivism. While Hart was in favor of retroactive amendment of criminal statutes to overcome the problems faced by the courts, Fuller was of the view that those statutes which failed to satisfy the test of morality could be ignored by the courts, depriving them of the legal effect. Fuller rejected the view of Hart for amendment of penal statutes with retrospective operation. The Hart-Devlin debate. The links between law and morality constitute the subject matter of an age-old jurisprudential debate. Two instances in English legal system during mid-20th century provided an opportunity for the debate between Hart and Sir Patrick Devlin. The first one was the decision in Shaw versus Director of Public Prosecutions. In this case, the accused published a diary containing personal advertisements for prostitutes in the city of London. It included the personal contact details, photographs, and descriptions of their services. He was prosecuted for two charges: conspiracy to corrupt public morality and living on the immoral earnings of prostitutes. He defended that he did not violate any statute enacted by the British Parliament. However, he was convicted on moral grounds. This case created a new offense of conspiracy to corrupt public morality, which was not covered by any criminal statute. Hart opposed this decision as a moral judgment, whereas Devlin justified the decision, holding that law can be used to enforce morals. The second one was the report of the Committee on Homosexual Offences and Prostitution, known as Wolfenden Committee Report of 1957. The British Parliament acted upon the recommendations of the committee and incorporated those recommendations in the Sexual Offences Act 1967, decriminalizing certain homosexual practices in specified circumstances. Devlin rejected the basic philosophy of the Wolfenden report, stating that those who deviate from conventional sexual morality might be in other ways hostile to society. Hart rejected Devlin's approach and argued that it is not morally possible to enforce the tenets of morality. This lesson is designed to discuss the significance of Dwarkin's criticism of Hart's positivism, Hart-Fuller controversy, and Hart-Devlin debate. Thank you.